rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning still. Our next case is Bradley Holmes versus DHHS, and we'll hear from the appellant.
Mr. Chief Justice, Associate Justices, and may it please the court, my name is Matt Wolf with the law firm Baker Donaldson, and I, along with my co-counsel, Bahati Mutisia, represent the appellee in this matter, the appellee being Bradley Holmes. This case is about ensuring consistent statutory construction so that small businesses and regulated persons like Bradley Holmes are afforded the protection of the mailbox rule for contested cases filed in the Office of Administrative Hearings under the Administrative Procedure Act, Chapter 150B of our general statutes. The sole legal issue is whether Rule 6E of the North Carolina Rules of Civil Procedure, the so-called mailbox rule, applies and adds 3 days to a filing deadline when a notice or paper is served by mail, in this case by the appellant, the North Carolina Department of Health and Human Services Division of Health Service Regulation, to extend the 60-day deadline that is provided for under North Carolina General Statute 150B-23F. This case is really quite straightforward. There are two operative statutes that are at play, Rule 6E, which is found in Chapter 1A, and 150B-23F. And the question is whether 150B-23F provides a differing procedure such that the mailbox rule under Rule 6E does not apply. There is no dispute that the general limitation for the filing of a contested case petition in the Office of Administrative Hearings is 60 days. And there are lots of exceptions that are found in other places in the general statutes. There's no dispute amongst the parties that the applicable deadline is 60 days. There's also no dispute amongst the parties about when that time commences. The agency has 3 options. It can deliver the notice electronically, it can deliver the notice personally, or it can place the notice in mail. In any of those events, the 60 days commences. There's no dispute that that's what 150B-23 requires, and that's what was the case here. In fact, the administrative law judge in her order to grant respondent's motion to dismiss, and then her amended decision granting the motion to dismiss, acknowledged that the 60 days would ordinarily run on Saturday, October 2nd, 2021. But because Saturday was a weekend, she granted Bradley Holmes, the petitioner in this matter, the benefit of Rule 6A of the North Carolina Rules of Civil Procedure, and said, as the agency has acknowledged throughout all of the argument in this case, that Rule 6A would apply and that the deadline would have been Monday, October 4th, 2021. My client, filing pro se petition for contested case hearing, filed the day after that, on October 5th, 2021. And so if the Rule 6E applies and Bradley Holmes gets the benefit of an additional 3 days, as we would argue that they should, then there's no question that the petition was timely and that this case should be remanded for a hearing on the merits of a survey that is now over 4 years old. If instead the court agrees with the majority of the Court of Appeals panel that 150B-23F is clear that there is no application of Rule 6E because there is a differing procedure that's provided in 150B-23, then we would acknowledge that the appeal of the petition for contested case hearing in the Office of Administrative Hearings was untimely, and that the Office of Administrative Hearings lacks subject matter jurisdiction. This is a case of first impression for this court. There have been various cases that are cited in the briefs on this that the Court of Appeals has addressed in part or in different ways the issue that's presented before this court. And in our reading of the underlying Court of Appeals opinion and the cited opinions that my friend relies upon in Pelley's brief, there has been inconsistency in the extent to which Rule 6E applies to contested case petitions filed in the Office of Administrative Hearings. And so we're thankful that this court granted our petition for discretionary review to provide a consistent and we believe a ruling that is also in line with the plain language of both of the operative statutory authorities. So if we can first look at 150B-23F. 150B-23F is the provision that Bradley Home relies upon, and that is the normal provision that a regulated entity or small person that's challenging an agency action, such as a licensure penalty, a tax, an adverse decision by a state employee, or in this case, a revocation of a licensure, would rely upon. And it does create a general limitation of 60 days. What 150B-23F does not do, it does not address in any way, shape, or form the computation of time. And so that's why we are asking that this court, in the same way that the Superior Court judge did and that the dissenting opinion by Judge Tyson did, is to look to the rules of civil procedure that also were enacted by the General Assembly that are designed to create consistency amongst all actions and proceedings of a civil nature, except when a differing procedure is prescribed by statute. And unlike, for example, the underlying statute in Smith v. Daniels International, where there was specific statutory language that said that Rule 6E should not apply because the deadline was 10 days from when the benefits disqualification decision was made, regardless of whether it was done by mail or personally delivered. We don't have that same language. We don't have that same differing procedure language in 150B-23. In fact, throughout my friend's brief, there is an attempt to read into 150B-23F the phrase regardless of. And as this court has consistently held in a variety of statutory construction cases, including Lunsford v. Mills, which both parties cite, this court should not insert or delete words in the statute that are not there. The court always assumes that the General Assembly knew what words it was using and what words it wasn't using. And so in an effort to exclude Rule 6E and the mailbox rule, this court should not add phrases into 150B-23F that are not there. The other challenge with the Court of Appeals opinion in this case and the administrative law judge's underlying order of dismissal and the agency's position, and this has been an issue that's been consistent through this entire appeal, is that there has been no attempt to ever explain why Rule 6A would apply. And there's other Court of Appeals cases that like Rummel's that have applied Rule 6A. And in this underlying case, there's a footnote that acknowledges that Rule 6A, which is the weekend or holiday rule of the civil procedures, rules of civil procedure, would apply and would give Bradley Home the benefit of those 2 additional days, but there would be no corresponding benefit to Rule 6E. So at one point, there was an argument advanced by the agency that the North Carolina rules of civil procedure just simply don't apply to actions that are initiated in the Office of Administrative Hearings because they are not actions in civil nature. Now that argument has been abandoned at this court, and rightly so, because there are many times, including the weekend example, but there's other examples where the state would want to have the benefit of the rules of procedure in administrative cases. So for example, there have been cases where Rule 11 and the certification requirements have been relied upon for petitions for contested case hearing. There have also been reliance upon Rule 15A and the amendment proceedings as an example. And routinely, the Attorney General's office relies upon the mailbox rule and other aspects of the rules of civil procedure in these cases that originate in the Office of Administrative Hearings and then make their way through the judicial review process and into our appellate courts. The only reason that the agency argues that Rule 6E should not apply is because it believes that 150B-23F is clear on its face and that it specifically excludes the use of the mailbox rule. But the language of 150B-23F simply does not support that position. There have been, as I mentioned, other statutes that the General Assembly has sought to not allow for the mailbox rule to apply when an aggrieved person or party is appealing an agency action, but the General Assembly did not see fit to do so in the general limitation under 150B-23F. Turning just to address briefly some of the arguments that have been presented by the agency in this case. There is a concern that if this court were to reach the ruling that is sought by Bradley Home and applied the mailbox rule to contested cases filed in the Office of Administrative Hearings under 150B-23, that there could be inconsistent results. Now, of course, there are already varying statutory timeframes that the General Assembly, in fact, even in just this agency alone, in my friend's brief, there are several different timeframes. So I don't think there's a reason that we should be concerned that sometimes it's 20 days, sometimes it's 30 days, sometimes it is up to 60 days. In fact, unlike most of the statute of limitations and actions that are initiated in the district court or superior court, one of the commonalities of cases that are brought before the Office of Administrative Hearings is the relatively brief time frame that an aggrieved person like Bradley Home has to take some action. And so quickly, oftentimes, that the aggrieved person doesn't even have the opportunity to retain counsel because they need to meet a 60-day deadline or 30-day deadline, as was the case here. So if there's ever an event where it would be appropriate to apply the mailbox rule to ensure that we address the closing of the gap that the mailbox rule is intended to design, it would be a situation where you have a very short period in order to take the action, in this case, filing the petition with the Office of Administrative Hearings. And another reason why we should not be concerned about the agency's argument that there could be some inconsistent results or there could be some confusion is that the agency has it in its control, not just this agency, but all the agencies in the state that are subject to the Administrative Procedure Act. They have the ability to control the means of notice. So if the agency decides it does not want to give the affected parties the benefit of the mailbox rule, it simply provides notice via electronic delivery, personal delivery, and then this whole issue goes away. In this case, it decided to issue the 2 revocation notices that are at stake in this appeal by dropping them off in certified mail. And the record shows that it actually took an additional 7 days. So cutting into our client's already very brief deadline to file these really significant and weighty notices that would literally prevent them from being able to continue to operate. The mailing of those notices would give the benefit to the agency of cutting their time from 60 days to 53 days. We are simply asking for the Rule 6E in the same way that Rule 6A applies as a gap filler to apply to 150B-23F and for this appeal to be considered timely and to allow for the Office of Administrative Hearings, which has a reputation, as Justice Berger knows, for being very efficient with handling contested cases and allowing for resolution of these disputes to actually occur for an agency action that was actually initiated over 4 years ago. There is also an issue that has taken up a substantial amount of briefing related to the question of whether the filing of the petition for a contested case hearing actually commences the contested case, or whether the contested case already originates from the fact that the revocation notices were issued. And the reason why this issue matters is the extent to which the court is going to consider the North Carolina Administrative Code that was promulgated by the Office of Administrative Hearings that very explicitly says that the rules of civil procedure shall apply to contested cases before the Office of Administrative Hearings. If this court agrees with Bradley Holmes' statutory construction in reading 150B-23 and Rule 6E in harmony, there's really no reason to get to that issue about whether this is a contested case. Our position would be, we agree with Judge Tyson that this was a contested case, that it was a contested case as soon as the revocation notice was issued. But again, even if this court were not inclined to agree with that interpretation, it would not prevent the application of Rule 6E because of the lack of any differing procedure that's set forth in the Administrative Procedure Act. Unless this court has any questions, I will reserve the remainder of my time.
Well, I do have one question. The way I understand your argument, you are urging us to look at the statute and the way it's written. Can you help me deal with the specific language of unless another statute or federal statute or regulation sets a time limitation for filing of a petition contested, and this is the part where it says against a specified agency, the general limitation applies. I just cut off the last part of 60 days. And so I don't read Rule 6A as being that specific. It's rule of civil procedure. So how do I reconcile that with your argument?
Yes, Your Honor. The way that I read that prefatory clause in 150B-23F is that it is the General Assembly acknowledging that in other substantive statutes, including, for example, 122C, that the General Assembly has actually shortened the time limitation from 60 days to 30 days, for example, with licensure penalties that this agency issues, or even 20 days when there is an issuance of a notice of suspension of admissions. So and then there are also lots of examples in the state employee context. There are examples in the environmental context. There's the example I referenced before that was raised in Smith v. Daniels International, where there was an employee benefits disqualification. So there's lots of examples where the General Assembly has created differing time limitations for the filing of a petition. And they usually do so not only by specific agencies, but also for specific circumstances. The application of the mailbox rule is not an attempt to expand the general limitation from 60 days to 63 days. In fact, that would be problematic because of course they can provide notice by personal delivery or by electronic delivery. what our position is, and has been consistent throughout this entire proceeding, is that when the agency chooses to provide notice by mail, as they're permitted to do, and when the general limitation is 60 days, because 150B-23F does not account for it. It doesn't say the mailbox rule applies. It doesn't say the mailbox rule doesn't apply. And there will be lots of ways in which the General Assembly could have constructed the statute to make that clear. It could have said, regardless of whether it's done by this manner, this manner, this manner, you have to have it filed within 60 days. That's essentially what it did in Smith v. Daniels. And there's other examples where the issuance of the notice does not start the time frame. It's the receipt of the notice. And in this 150B-23, it is clear. It's 60 days. It commences if it's personal delivery, electronic delivery, or dropping it in the mailbox. But what it doesn't clarify, and what the reason why this court should look to the rules of civil procedure, is because of the fact that you have this inherent inconsistency with the ability to provide notice by mail. So and again, I think there's an issue about sort of what that word general limitation means in that context. And the way that I read it, as somebody that appears before the Office of Administrative Hearings in lots of different contexts, is an acknowledgement that there are other substantive statutes that provide for different time frames than 60 days. And in some cases, those not only just provide different time frames, but they also provide different mechanisms for when the notice is commenced. And they may, it's not before this court, but there may be circumstances like, for example, in Smith v. Daniels, where that specific statutory language forecloses the application of Rule 6E. But this general provision in the Administrative Procedure Act is not that kind of case. Unless there are any further questions, I would reserve the remainder of my time for rebuttal. Thank you.
Thank you, counsel. Hear from the appellee.
Mr. Chief Justice, Associate Justices, and may it please the court. My name is Carrie Boehm, and I represent the North Carolina Department of Health and Human Services, the appellee in this matter. A person's right to sue the state is created by statute, and a person has to comply with all of the requirements of that statute in order to avail itself of the right to sue the state. Here, the Administrative Procedure Act governs the appeal of agency notices and certain actions taken by state agencies. In enacting the Administrative Procedure Act, the General Assembly contemplated and created an express mechanism to sue the state and appeal such agency actions. But in order to bring such an appeal, a party must comply with the requirements set forth in the APA, including the express 60-day deadline to file an appeal. This court and the Court of Appeals have routinely and repeatedly concluded that absent strict compliance with the provisions of the APA, including the timely filing of a petition, the Office of Administrative Hearings lacks subject matter jurisdiction and is without power to adjudicate the appeal. Here, the sole question is whether Rule 6E applies to extend the 60-day deadline contained in 150B-23F. The majority of the Court of Appeals correctly held that it does not, and the department respectfully requests that this court affirm the Court of Appeals decision below.
Do you agree that Rule 6A applied?
Your Honor, the Administrative Procedure Act is silent as to the application of Rule 6A, and we are without any law or case law expressly holding that it does. In contrast, the APA is not silent as to the clear 60-day deadline. And
I'm just trying to figure out if there's any logical reason why we would say 6A applies, but not 6E.
Understood, Your Honor. I think it's more as a practical matter that courts are not open for business. The Office of Administrative Hearings is not available to process and file petitions on weekends.
Well, yeah, so you're getting to my next question, which is, could the petitioner have filed on October, or whatever the date was?
Yes, Your Honor. On day 60 was October 2nd, and you're correct that Conceivably, she could have because she availed herself of the ability to file by email. So she merely sent an email containing this petition on October 5th. Conceivably, she could have done that on October 2nd. However, it would not have been processed and file stamped by the Office of Administrative Hearings until the following Monday, which would have been October 4th, day 62.
If we didn't let her file on Saturday, or the petitioner, Bradley Holmes, if we didn't let the petitioner file on Saturday, then the petitioner wouldn't have gotten the full 60 days, right? I mean, if we hadn't, if we took the position 6A doesn't apply either, then the petitioner wouldn't have gotten the full 60 days, right?
Yes, Your Honor. So if the petitioner she wasn't able to file on a Saturday and she had to wait till the following Monday, yes, the 60th day would have expired.
But under your reading, though, it seems like we can't apply 6A. Tell me if that's incorrect.
Your Honor, so there is no case law, there is no law to that effect. The APA specifically holds, though, in the language of the statute at issue here, 150B23F, mandates a 60-day deadline, and it prescribes an identical deadline regardless of delivery method. And that's the clear statutory import and intent of the General Assembly. There is no corollary provision in the Administrative Procedure Act to address the implication of holidays or weekends on the timely filing. And again, as a practical matter, the court isn't open. The cases cited by the appellant in support of the proposition that Rule 6A does apply are cases that involve, as background, a lower court will calculate the 60-day deadline or 30-day deadline, as was the case in Gummels, and set forth what the applicable deadline was by applying Rule 6A. But those courts have never expressly said or held that 6A definitively applies to these administrative appeals. So turning to the language of the statute that is at issue, this court, of course, routinely applies canons of statutory construction, including that we should afford the plain and definite meaning to statutes that are clear and unambiguous. We presume that the General Assembly chose its words with due care, and courts are without the power to superimpose provisions where the General Assembly did not include such language in a statute. And here, 150B23F is clear and unambiguous. The plain language makes it clear that it's a 60-day deadline that applies regardless of the delivery method employed by an agency. The statute consists of 7 sentences, and the first 2 are material here. The first sentence, as Justice Berenger alluded to and explained, begins with a qualifying clause that unless another statute prescribes a separate deadline to file a petition against a specified agency, the general limitation is 60 days.
I'm sorry to interrupt you again, but I'm working on this. What about the argument that this provision tells you when the 60 days begin? Clearly they begin in the case of service by mail when the notice is mailed, but they don't tell you how to calculate the end. And so do they tell us what to do when that day 60 falls on a weekend? If they don't, and if we'd apply Rule 6A to that, why wouldn't we apply Rule 6E to service by mail? And I'm sorry if that's repetitive, but
No, I understand you're trying to reconcile the two. Yeah. Absolutely. So I think it's important that the Administrative Procedure Act, and this statute in particular, is silent as to what do we do if it falls on a weekend or a holiday, and how do we apply, what do we do to calculate the 60-day deadline. The statute is not silent, though, that it's 60 days. And practically speaking, courts have always and routinely applied 6A to afford parties until the following Monday or next business day.
Okay, but if you analogize this to like a statute of limitations, mm-hmm. if the last day in the limitations period falls on a Saturday and you can't file on that Saturday, well, you better file on that Friday, right? You don't get to say, oh, well, last day was a Saturday, I filed on the Monday, so I'm good.
Correct, Your Honor. Yes.
So how is that different?
So here, I think 6A functions more as a background rule. And while we don't have case law or any statute that directly requires the application of Rule 6a, it's in the background and courts therefore can apply it. Here, the General Assembly promulgated and codified a clear and express 60-day deadline, and by doing so, including by requiring the same 60-day deadline regardless if the delivery is mailed, or if the notice is mailed, if the notice is emailed, or if the notice is personally delivered, indicates the General Assembly's intent to have an identical deadline regardless, and therefore 6E does not apply. And I think my friend referenced the Smith v. Daniels case, which was decided in 1983 by the Court of Appeals. The facts here and the statute here is analogous, where in that case, the Employment Security Commission denied complainant's benefits, and he had 10 days to timely file an appeal under the applicable statute. There, the General Assembly found, or the General Assembly, excuse me, the Court of Appeals found that because the statute contemplated an identical deadline for two separate delivery methods, personal delivery or mailing, that was clear indicia of the legislative intent that it was an identical deadline regardless of delivery method. And that intent precludes the application of Rule 6E to extend the deadline.
And before you move on, I believe your friend on the other side is arguing that you are arguing that there be placed the words regardless of method. And you have previously said that under the canons of construction, we can't add words. Can you help me understand your position there?
Yes, Your Honor. So the second sentence of 150B 23F at issue here is that it's the time limitation runs when the notice is given to the persons aggrieved by personal delivery, electronic delivery, or placing it in the mail. And it's disjunctive. There's three options there. And there, we read it to mean that it's regardless of delivery method that that time limitation starts to run, and that the General Assembly codified its pure intent that Rule 6E does not apply to differentiate. So turning back to...
I'm sorry, Counsel. Let me make sure I understand. I believe you said the legislative intent was to have identical deadlines regardless of delivery method. But in response to an earlier question, didn't you acknowledge that if someone wanted to file on a Saturday, they couldn't, so they don't have an identical filing deadline?
They have an identical filing deadline absent application of Rule 6A. So if, like as in this case, the 60th day runs on a Saturday, OAH typically applies Rule 6A to move the deadline to that Monday. We don't have any case law or authority to support the application of Rule 6A. It's more just as a practical matter, that's what the Office of Administrative Hearing does. Turning back to the first sentence of 150B 23F, I think the appellant disregards the qualifying clause that Justice Berenger referenced, that unless another statute prescribes otherwise, the general limitation is 60 days. And the appellant contends that the word general used to modify the noun limitation invites application of Rule 6E. But it's our contention that Rule 6E is not another statute prescribing a deadline to file a petition for contested case against an agency such that it cannot apply. The general limitation language instead is the catch-all. It's 60 days unless another statute says otherwise. And as my friend referenced, there are other statutes that prescribe a 10-day deadline, 20, 30, 45-day deadline, and that's what it's referencing. It's not an invitation to apply Rule 6E. Instead, it's the General Assembly's recognition of the fact that there are shorter deadlines prescribed. In its brief, the appellant also raises a contention that the notices themselves constitute contested cases, and they do not. The Court of Appeals correctly determined that because a contested case does not exist until a petition is filed with the Office of Administrative Hearings, the rules of civil procedure do not apply to extend the deadline prior to the filing of that case. And there are two administrative rules that are of importance here. One is 26 NCAC 0101, which provides that the rules of civil procedure apply in contested cases. And a second is 030116, which provides that time computations in contested cases before OAH are governed by Rule 6. Both of those rules make clear that the rules of civil procedure apply when a contested case exists. However, there are two provisions of the Administrative Procedure Act that also define what a contested case is and what affirmative steps are required in order to initiate a contested case. And until a party takes those independent affirmative steps, they file a petition, they pay the filing fee, there is no contested case, and the rules of civil procedure can't apply. If the mailing of an agency's notice or the delivery of an agency's notice on its own, the agency issues a penalty, the agency suspends admissions at a facility, constituted a contested case, it would upend the Administrative Procedure Act entirely. It would mean that every single penalty notice that goes out constitutes a contested case without any action by the aggrieved party, and that cannot be the intended result of the General Assembly. Instead, it is incumbent upon receipt of the notice affecting their rights for the party to either choose to accept the agency's decision or challenge it through the procedures outlined and required by the Administrative Procedure Act. And prior to filing a petition, no contested case exists, so the rules cannot apply. In this case, the appellant failed to comply with the 60-day deadline mandated by statute, and the Office of Administrative Hearings lacked subject matter jurisdiction. And just as a factual matter, the agency mailed the notices on August 3rd, 2021. We have tracking, United States Postal Service tracking, indicating for one of the notices was delivered on August 6th. It was retrieved from the appellant's post office box on August 10th. She did not file the petition until October 5th, 63 days after the mailing. As a policy matter, clear jurisdictional deadlines benefit everyone. They benefit courts, they benefit the parties, and administrative simplicity is encouraged. It makes it clear for the court to know whether they have authority to adjudicate an appeal, and it makes it clear for the parties whether they have authority to litigate an appeal. And it's valued by everyone to have a clear jurisdictional deadline, and the Supreme Court of the United States has explained that complex jurisdictional tests unnecessarily complicate matters.
Is it that complicated to add 3 days? I mean, don't we do it all the time?
Your Honor, we do. However, this isn't a matter of prejudice or complication for the agency. It's just the interpretation of a clear jurisdictional deadline. It is on its own. The General Assembly did not contemplate application of Rule 6C, and if they had wanted to prescribe a separate method, if the agency chose to mail something, you get extra time, they could have done so in the statute. But this statute, the Administrative Procedure Act and 150B23F, are more specific. They apply only to contested cases, whereas the rules of civil procedure apply to civil proceedings across the state. And to that point, this court has previously explained that laws on the same subject matter should, of course, be read harmoniously to produce consistent legislation wherever possible. But here, Rule 6C and 150B23F do not concern the same subject matter. A contested case under the APA is a special form of civil action created solely by statute, whereas the rules of civil procedure apply to initiate and the rules of civil procedure apply inside a civil action once you have a case filed. 150B23F is just a procedure for someone to avail themselves of the rights under the APA and create and file a case. And in addition, the Administrative Procedure Act, it affords parties, including small businesses, due process rights, but it's not unlimited. Instead, those parties who may be affected must avail themselves of the strict requirements set forth by statute. including the 60-day deadline in 150B23F. The Office of Administrative Hearings already affords flexibility to parties, including pro se litigants, by permitting the filing of a petition by email. And so taken together, their rights are protected. There is a due process procedure to appeal such actions. In this case, the petitioner's petition was untimely. The Office of Administrative Hearings lacked subject matter jurisdiction. Rule 6E did not apply to the very specific statute in 150B23F that mandates a 60-day deadline. Anything this court and the Court of Appeals have concluded that anything short of a timely, properly filed petition under the Administrative Procedure Act renders the Office of Administrative Hearings without subject matter jurisdiction to adjudicate the sought appeal. And unless the court has any further questions, the department would just request that this court affirm the majority's decision below. And thank you for your time.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. My friend characterizes this as a clear jurisdictional deadline. Respectfully, there have been 5 jurists that have considered this issue thus far below. 3 have sided with my friend and 2 have sided with Bradley Home. And so I would certainly argue that this is not a clear jurisdictional deadline that would not be worthy of this court's time and resources. Following up on Justice Allen's line of questioning related to the application of Rule 6A, my friend acknowledged that it was a practical matter that the sort of the weekend holiday provision in Rule 6A would apply to contested case petitions filed at the Office of Administrative Hearings. And I would agree with my friend that there is no case law that I've been able to find or that's cited in either of our briefs that actually explicitly holds that Rule 6A applies to the 60-day deadline. But there now have been at least 2 Court of Appeals opinions that have acknowledged, without actually addressing the issue, that when a deadline falls on a weekend, as it did in this case, that you get the benefit of Rule 6A and that it's extended to, in this case, the Monday, which the agency does not appear to be arguing, or in the case of Gummels, that actually you get the benefit. In that case, they got the benefit, I think, of actually in another 2 days. The deadline was on Sunday, but Monday happened to be the 4th of July, and so you got the benefit of the deadline being Tuesday, July 5th. The mailbox rule is another practical rule that is an acknowledgement by the General Assembly that things simply take longer to get there when you put them in the mail versus when you send them by email or you hand deliver them. And so for the same reasons that the agency acknowledges that Rule 6A as a practical matter has been applied and is applied in this case, Rule 6E should be applied. Now, my friend argues that 150B-23 is silent as to how you deal with the deadline when it happens to run on the weekend, but it isn't silent about how you calculate the deadline when it's mailed. And there is nothing in 150B-23 that contemplate or in any way provides a differing procedure, which is what the rules of civil procedure would require in order to be able to demonstrate that Rule 6E should not apply. What I think, if I understand the colloquy between Justice Allen and my friend correctly, what I think the agency is actually asking for is this court to change the 60-day deadline from either, if they allow for the weekend rule and Rule 6A to apply, to a 62-day deadline or a 59-day deadline, because there is no way that an aggrieved person like Bradley Home or anybody else that receives a notice or that is sent a notice by mail can avail itself of the Office of Administrative Hearings over the weekend or on the holidays. The administrative code that my friend recognized treats those as having been filed on the next business day. And so if we don't look to Rule 6 to address these practical matters, both Rule 6A and Rule 6E, what we're going to end up doing is actually shortening, in this case, a 60-day deadline to 59 days, or in some cases, a 20-day deadline to to potentially a 17 or 18-day deadline, depending on when it falls. And so it's consistent with the rules of procedure. It's consistent with the policy rationale that this court and others have acknowledged for the Rule 6E mailbox rule, that Rule 6E should be applied to 150B-23. The final thing that I just want to address, unless the court has other questions, is this issue about the contested case and whether the contested case starts after filing or before when the notice is issued. And there is some discussion of this in Judge Tyson's dissenting opinion, and so both parties did address it in the briefing. But frankly, this court only needs to address the statutory construction issue. Because if the court agrees with Bradley Home that 150B-23 is silent as to the application, or does not have a differing procedure, and that Rule 6E does apply, then it doesn't need to reach whether the contested case started when the notice was issued or when the contested case petition was filed. Frankly, even if it were to hold, as Judge Tyson did in his dissenting opinion, that it is a contested case already, the only reason that has any relevance at all is because then it makes clear that the Office of Administrative Hearings rules in the administrative code apply and that the rules of civil procedure govern. But we're here really on a statutory construction question. And so if this court sides with my friend and doesn't believe that Rule 6E applies, even if the rules, the administrative rules that the OH has promulgated, they would be inconsistent with statute. I mean, it's just a clear, sort of law school levels of authority issue. And so I would invite this court to address the statutory construction issue head on and to conclude that Rule 6E applies to the time limitation for filing set forth in 150B-23F, because there is no differing procedure that's set forth in that. I would ask that this court not take the agency's invitation to actually alter that deadline from depending on it when it falls, either a 59-day or a 62-day or whatever other day, and actually to make this administrative process, which is already very complex, simple and fair to those small businesses and regulated entities that avail themselves of the Office of Administrative Hearings by applying the mailbox rule to the contested case deadline. Unless the court has any other questions, I'm going to take the admonishment by the court that I am not required to take my full time. Thank you very much.
Thank you, counsel. Ms. Clerk.